However, even in the context of an internal armed conflict, Geneva Convention 3, relative to the treatment of prisoners of war, applies where the parties to the conflict have agreed that the Convention shall apply. In this respect, the Appeals Chamber recalls the European Community Monitoring Mission's instructions to its monitors on the implementation of the Zagreb Agreement, which indicated that the Geneva Conventions were to be applied to the prisoners of war. In an order issued on 18 November 1991, Lieutenant General Zivota Panic directed the JNA units in the Vukovar area, including OG South, were to observe all aspects of Geneva Convention 3. Furthermore, Colonel Nebojsa Pavkovic advised the monitors of instructions from General Raseta to the effect that Croat forces would not be evacuated with the rest of the humanitarian convoy, but remain as prisoners of war, and that the Geneva Conventions would apply. The Appeals Chamber considered that this provides sufficient evidence to conclude that the JNA had agreed that the Croat forces were to be considered prisoners of war and that the Geneva Convention 3 was to apply. Turning to Mr. Šljivančanin's responsibility for the welfare and security of the prisoners of war in the context of Geneva Convention 3, the Appeal Chamber recalls that the fundamental principle enshrined in Geneva Convention 3 that prisoners of war must be treated humanely and protected from physical and mental harm applies from the time they fall into the power of the enemy until their final release and repatriation. It thus entails the obligation of each agent in charge of the protection or with custody of the prisoners of war to ensure that their transfer to another agent will not diminish the protection to which the prisoners are entitled. Further, although the duty to protect POWs belongs in the first instance to the detaining power, this is not to the exclusion of individual responsibility. The Appeals Chamber thus finds that Geneva Convention 3 invests all agents of a detaining power into whose custody prisoners of war have come with the obligation to protect them. It considers that all state agents who find themselves with custody of POWs owe them a duty of protection, regardless of whether the investment of responsibility was made through explicit delegation, such as through legislative enactment or a superior order, or as a result of the state agent finding himself with de facto custody over prisoners of war, such as where a prisoner of war surrenders to that agent. The Appeals Chamber therefore considers that Mr. Šljivančanin was under a duty to protect the prisoners of war held at Ovčara, and that this responsibility included the obligation not to allow the transfer of custody of the prisoners of war to anyone without first satisfying himself that they would not be harmed. Mr. Mrkšić's order to withdraw the JNA troops did not relieve him of his position as an officer of the JNA. As such, Mr. Šljivančanin remained an agent of the detaining power and thus continued to be bound by Geneva Convention 3 not to transfer the prisoners of war to another agent who would not guarantee their safety. For the foregoing reasons, the Appeals Chamber finds that the trial chamber erred in finding that Mr. Šljivančanin's duty to protect the POWs pursuant to the laws and customs of war came to an end upon Mr. Mrkšić's order to withdraw. In light of these findings, the Appeals Chamber turns to consider whether Mr. Šljivančanin's failure to act upon learning of the order to withdraw the JNA troops from Ovčara substantially contributed to the murder of the prisoners of war by the TOs and paramilitaries. The appeals chamber must be satisfied beyond reasonable doubt that the prosecution has demonstrated that Mr. Šljivančanin substantially contributed to the killings by his inaction, and that when account is taken of the errors committed by the trial chamber, all reasonable doubt concerning Mr. Šljivančanin's guilt has been eliminated. In this regard, the appeals chamber recalls that aiding and abetting by omission implicitly requires that the accused had the ability to act but failed to do so. The trial chamber found that at the relevant time Mr. Šljivančanin was exercising the power and authority conferred on him by Mr. Mrkšić to conduct the evacuation of the hospital, and as such he was exercising de jure authority with respect to the relevant JNA military police forces of OG South rather than pursuant to his mandate as security organ. Accordingly, an order from Mr. Mrkšić terminating any specifically delegated duty for the security of the prisoners of war would also have removed the power and authority that Mr. Šljivančanin had over the military police of the 80th Motorized Brigade. Having said this, the appeals chamber considers that even though Mr. Šljivančanin no longer had de jure authority over the military police deployed at Ovčara, he could have informed the military police deployed at Ovčara that Mr. Mrkšić's order was in breach of the overriding obligation under the laws and customs of war to protect the POWs and thus constituted an illegal order. Issuing an order contrary to Mr. Mrkšić to the military police of the 80th Motorized Brigade was a course of action that would have required Mr. Šljivančanin to go beyond the scope of his de jure authority, which had been effectively removed by virtue of Mr. Mrkšić's withdrawal order. Nonetheless, the legality of Mr. Mrkšić's order required Mr. Šljivančanin to do so. The appeals chamber considers that in certain circumstances an officer may be required, within the limits of his capacity to act, to go beyond his de jure authority to counteract an illegal order. The appeals chamber further considers that Mr. Šljivančanin could have attempted to persuade Mr. Mrkšić to abort the withdrawal order. Had his attempts to persuade Mr. Mrkšić not been successful, when Mr. Šljivančanin telephoned Belgrade in order to speak to General Vasilievich, he could have sought the General's assistance on this matter. The appeals chamber considers that had Mr. Šljivančanin been successful in securing the return of the military police to Ovčara, the murder of the prisoners of war would have been substantially less likely. The appeals chamber thus finds that Mr. Šljivančanin's failure to act pursuant to his duty under the laws and customs of war substantially contributed to the murder of the prisoners of war. For the foregoing reasons, the appeals chamber finds, Judge Pokar and Judge Vas dissenting, that all the requirements for a conviction for aiding and abetting murder by omission have been met, and is satisfied beyond reasonable doubt that the prosecution has shown that when account is taken of the errors committed by the trial chamber, all reasonable doubt concerning Mr. Šljivančanin's guilt has been eliminated. I now turn to the sentencing appeals. In his 11th ground of appeal, Mr. Mrkšić argues that the trial chamber wrongly considered aggravating and mitigating circumstance that the laws of the former Yugoslavia on the punishment of those found convicted of like offences could never refer to abettors, but only to perpetrators of such crimes, and hence that his sentence is too severe and unjust. The appeal chamber rejects Mr. Mrkšić's challenges to the trial chamber's assessment of the aggravating and mitigating circumstances, and also finds that Mr. Mrkšić fails to identify any discernible error concerning the trial chamber's consideration of the general sentencing practice of the former Yugoslavia. Therefore, Mr. Mrkšić's 11th ground of appeal is dismissed in its entirety. Under its 4th ground of appeal, the prosecution argues that the trial chamber erred by imposing a manifestly inadequate sentence on Mr. Mrkšić, as insufficient weight was given to Mr. Mrkšić's role and responsibility and to the gravity of his crimes, namely aiding and abetting the torture and cruel treatment of the approximately 200 prisoners held at Ovčara, and aiding and abetting the murder of 194 of them. Consequently, it requests that Mr. Mrkšić's sentence be increased. With regard to Mr. Mrkšić's role and responsibility, the appeal chamber finds that the trial chamber duly considered his position and role, both in the context of how he contributed to the commission of the crimes and in the context of assessing whether his conduct as an officer could be considered as a mitigating circumstance. The prosecution's arguments are dismissed. With respect to the prosecution's submissions that the trial chamber gave insufficient weight to the objective gravity of the crimes, the appeal chamber emphasizes that while consideration of the gravity of the offense involves, in addition to consideration of the gravity of the conduct of the accused, consideration of the seriousness of the underlying crimes, the gravity of the crime does not refer to a crime's objective gravity.